which I've told to class after class for 30 years, more than that, and I always work it into classes, even into civil procedure classes, where it doesn't fit. But it starts. I once represented a woman named Geraldine. Her name was, and she was charged with her third Harrison offense. It was this Harrison narcotics law, which was really, I thought, very draconian and repealed because it was so draconian, although now the drug laws are even worse. But it dealt with heroin, and maybe, I think heroin, see this is pre-cocaine, and for your first possession of heroin, much less sale, was 5 years, no probation, no parole, no mercy. And for the second one, it was 10 years, and absolutely no good time. I mean, every day of 10 years for the second one. And she was up on her third Harrison, and it was, and that was 20 years. 20 years, every day of 20 years. And she had spent 15 years in prison already. And she was in her early 40s, and there was no defense really, because she was an addict, and she would get in with some man and sell for him to get her own supplies.
What was her ethnicity?
Black. She was black. All my clients were black. I had one or two white clients, but mostly black, and mostly black juries also. I mean, a few white people on them, but mostly black. And it was a custom. 20 years, every day of 20 years, was so horrendous that the custom was to give a plea bargain to plead to a D.C. code offense. See, this was a federal offense. And but the prosecutor wouldn't give me the deal because he said he wanted to try a case against me, that it thought it would be interesting. And I said, well, I'll give the case to somebody else then, And he said, no, I won't give the deal to anybody. And so I sent her to, I thought about an insanity defense. That was the only possibility. And so I sent her to the public hospital, St. Elizabeth's, and they said that she had this mental illness, and it was inadequate personality. And that was actually in the Diagnostic and Statistical Manual of the day. And what it really meant, it applied particularly to addicts, she had been on heroin since she was very young, and she really hadn't developed the normal, personality controls or behavior controls. And she was one of the people. I represented people who didn't know who their father was regularly, but she didn't know who her mother was. I mean, she had just grown up sort of on the streets. And so I had this diagnosis, inadequate personality, a mental illness in that day, and I had these expert witnesses, these psychiatrists who were a little inadequate themselves, but we went to trial. But I was just in a rage at the prosecutor for not giving me the deal and for risking this woman spending 20 years of her life in prison. And but then this lucky thing happened. We were sent out to Judge William B. Bryant, who was this African American judge, the only one, the first one on the D.C. federal court, who was just this great man, a wonderful man. And he had been a prosecutor himself. He had been the first assistant U.S. attorney, African American, in D.C. And then one day, when he found himself getting overly excited about convicting a brother in a death penalty case, he went down and resigned and became a defense lawyer that day. And he was a fabulous defense lawyer. handsome man, handsome as a movie star, really. And he, so we were sent out to him for trial, and I knew that he wouldn't give this woman 20 years, so that whatever the jury did, he was going to give me a directed verdict, I thought, so I felt like I had a little cushion, which I would never have otherwise, but so what I did this wild thing. I was just thinking about this the other day, which is I put the first 12 in the box. I did no voir dire. I just said that's the way they did jury selection there. They would put 12 and then you'd question them and then replace them, as you eliminated them on voir dire. But I just said the defense is satisfied with this first 12.
Did this occur to you right then, or had you thought about this the night before? And
once we learned that I was getting Judge Bryant, I thought I'd do that because, see, then the prosecutor, and it worked because he was thrown completely off because he wasn't ready to go with his case. He didn't have his witnesses there, he hadn't prepared them, because he thought we'd spend at least a day getting a jury, And so he's not going to say he's not satisfied, but then the trial went on, days for days, and I thought, what have I done? This is the worst looking jury I've ever seen. I mean, they're just awful looking people, and they were just, and especially juror number 6, she looked like, they were a lot of white government workers. I mean, those are the people that you throw off generally on your criminal juries, and also they were old black men. They're not good either, and it was just the worst looking jury you ever saw. But this one woman, juror number 6, she had these real thin lips, and she looked like she cut her hair with a bowl. And she would just, everything I would say, she would just roll her eyes, and shake her head. And I just thought, why am I here with these people? But then I thought, there's Judge Bryant, my savior. And but anyway, we gave the closing arguments. But I expected him to give me the directed verdict before the jury went out, because it's very hard after the jury has come back to direct a verdict, though the law gives you the power to do it. And but he didn't. He sent them out, and so I went back and I said, Judge, this jury, what are you going to do when they come back? And he says, well, you just wait. Juries are a lot better than you think they are, So they were out for 3 days. And meanwhile, I just have to tell you, the trial was extremely hard fought because I was so mad at the prosecutor. And at one point, when we had a little break and we came back in, and he says, Judge, Miss Babcock has threatened me. And he says, come to the bench. And he says, what did she say? And I said, if he asked that question one more time, I was going to refer him to the disciplinary committee. Not much of a threat, really. But anyway, the jury, the whole time, Geraldine just sat there. See, she just sat there and watched this as I presented the whole sad story of her life, and growing up on the streets, and when she wasn't in prison, she was addicted to heroin. It was a terrible addiction, the worst kind, and she did, just never showed anything. But the jury comes back not guilty by reason of insanity, which means she goes to a mental institution since she's not too sick. She'll be out shortly. Instead of prison, and she doesn't go to prison at all in those days. And so Geraldine just burst into tears and threw her arms around me, and she said, I'm so happy for you. And Judge Bryant just nearly fell off the bench laughing. But meanwhile, juror number 6 comes up, and she said, well, it took me 3 days, said we went out 11-1 for conviction, but I brought them around. And she said, I grew up in Washington, D.C. too, and the picture that you painted of her life, So the whole time she was rolling her eyes, it was sympathy, and I just mistook it. But I just wrote up that part of the story for an article about 12 Angry Men. It's the 50th anniversary of the movie 12 Angry Men. And I was saying, people sometimes say, could that happen, that one person would bring around all 12, and so I have that story where it actually did happen.
It's a wonderful story.
So.
You're running the first public defender's office, you're in charge, you're trying cases, you're doing the very thing you love. Why in the world would you leave it, and of all places, to come to Stanford Law School?
Far away, right. Well, it was sort of a combination of several things. One is that I did see this window of opportunity opening, affirmative action for white women that happened at the end of the 60s and early 70s, when it went from 3% of the nation's law students being women when I was in law school overnight to 20%. And women were just flooding. It's partly the Vietnam War, partly it was an offshoot of the Civil Rights Movement, and women coming to law school, because that's what women do when they're starting a movement. They go to law school, and so the law schools weren't prepared to receive this sudden real influx of women, and so you couldn't get a draft deferment to go to law school, and so that cut down the top applicants, male applicants. So the law schools were all looking to hire a woman. So I really saw the top law schools were looking, and also the women came in. This new generation of women coming off of the Civil Rights Movement came in, and they said, what's going on here? I mean, there's nothing for us. We should have courses, and we should be mentioned in the courses, and we should have teachers, and the students themselves generated these courses, and Women and the Law, it was called, and then they got me to come teach one at Georgetown, and then I went up and taught one at Yale, just flying up every week from my public defender's job, and I learned, a tremendous amount about this new movement and about women and sex discrimination. We didn't yet call it that. So we called it like women and the law, like women and psychology, or women and elephants in the law, or something, And so, but anyway, so for a little period there, the law schools were really intense on hiring a woman, and I just thought, this is my chance. And I also got divorced from my first husband, and I'd always thought the next step with him was going to be that we were going to start this little law firm and do criminal work and represent rich gamblers and poor people, see, kind of Robin Hood practice. And so that dream, didn't seem realistic at the time anymore. And I saw that law schools where somebody had been, I was out 10 years by now, and I'd been a public defender and a criminal defense lawyer, but I hadn't clerked on the Supreme Court, I hadn't been an officer of the Law Review, and those were the usual credentials for, and I was getting kind of old for a law professor starting out in those days. And so people thought, that too much practice dulls your mind. So I saw this opportunity, and so I decided to do it. And then at Washington, D.C., my hometown, which is I felt like I was never going to leave it if I didn't, try something else. And California, of course, was, magical in those days. Still is, really. So I had